Good morning. Welcome to Law Power Hour. Good morning, Ray Saloom. Welcome back.
Thank you. Thank you, Barry. It's
You
nice to
know,
be back.
Ray Saloom is a premier bankruptcy lawyer, and I can't begin to tell you what a good lawyer he is. I handled a case for a man who went to a podiatrist, and the podiatrist messed up his feet. I won't go into the merits of it, but the podiatrist filed for bankruptcy. So when he filed for bankruptcy, that put a stay, and Mr. Saloom's going to explain all this to you this morning, on everything that went on. And there is a trick to getting a stay off. You have to prove that there's insurance. In other words, that the podiatrist had his own insurance to cover the risk. It's kind of important to keep in mind because one of our listeners had called about an injury that he had at his apartment complex, roof caved in, and there may have been insurance on the building, and then they sold the building, they never got the insurance information, and that's why people like Ray Saloom are around. Short and long of the whole story is Ray Saloom got the stay lifted. Now the man's going to be able to recover. And this man, it's really important for him to recover. He's 94 years old. If he'd been stuck in the bankruptcy court, we wouldn't have had a chance. So thank you, Ray.
Oh, my pleasure. Thank you, Barry.
Now, people always call me and say, can I file for bankruptcy? Well, when I went to law school 54 years ago, kind of scary to think of going to law school 54 years ago, but it's true. The bankruptcy code was totally different. The bankruptcy code has not been around that long, has it?
No, and it's changed quite a bit, especially over the last 10, 15 years.
Right. And what was it, in the 30s, the bankruptcy code evolved, is that correct?
Correct. And it primarily was written for corporations that failed to handle that, and then the consumer part of the bankruptcy code developed in the 70 years since.
The President of the United States has shielded his assets by using the bankruptcy code on at least 3 occasions that I'm aware of. Isn't that true?
That's correct. Yeah.
So it's there to protect assets and to protect individuals, to make sure that you're not stripped bare.
It's an excellent way to look at it as a tool, a financial planning tool.
And you individuals out there, you can use it as a financial tool. We're going to talk about that today. One of the things I learned from Ray last time is really important. If you have a second mortgage on your house, you can get rid of a second mortgage that way, can't you?
In some cases, when the value of the home is less than the value of the first mortgage, you can strip off the second in a Chapter 13.
Don't mind Ray, he never sang in the choir. His voice isn't very, okay, we'll get it up there a little bit. Okay, so let's talk about bankruptcy for a minute.
Sure.
If an individual wants to file for bankruptcy, there are 2 ways of doing it, correct?
Correct.
There's a Chapter 7.
Chapter 7, which is a straight liquidation that's often referred to as the fresh start bankruptcy. And that's a bankruptcy that most individuals do file. It's basically you're so far under debt and you don't see a way out. You're asking to start all over again. And when you do file a Chapter 7, you have to list all your assets, all your liabilities. You're allowed to keep a certain amount of property. When you file a Chapter 7, if I can explain, all the assets, everything you own or have an interest in becomes property of the bankruptcy estate. You're allowed to keep property that you can exempt. For example, equity in a home, automobile, tools, pension.
Wait now. I can file for bankruptcy and keep the equity in my home?
Up to a certain amount.
Okay, what's that amount?
I have to digress for a second, because when you file bankruptcy, you get to choose between the federal exemptions and the state exemptions. And this is very interesting. I'll give you an example. Under the federal exemptions, the equity is capped at $22,500 in a home. If you take the Michigan entireties exemption, it could be unlimited. And I'll give you an example of that. For example, if husband and wife own the home together in Michigan by entireties, husband and wife, and all the debt is in the husband's name only, the wife is not liable for any of the debt. The husband can file a Chapter 7, choose the Michigan exemptions, the entirety's exemption, so that there could be 200,000 equity in the home, would not have to sell the home. If his wife is joint with him, then he would be capped at 35,000 under Michigan, and the wife's 35, so that would be 70,000 that they could exempt.
Okay, suppose I'm a widower. I have to throw that out there because there are some widows and widowers in our audience today may want to file for bankruptcy, and they're unfortunately solo now. So what's the exemption?
The maximum for over age 55 is 55,000 equity in a home if you take the Michigan exemption. But you can't exempt cash. If you take the Michigan exemptions, you want to time it so that the date of filing you don't have any money in your checking account. Otherwise, a trustee will scoop it up. You can't keep tax refunds, but you can keep more equity in a house.
What about my pension?
That's unlimited in both. It's exempt under IRS code, and it would be exempt under federal or state. It's both.
This is like giving Ray Saloom a final exam. Tell people how to get a hold of you, Ray, so they can, we're going to go on with these questions, but.
Oh, thank you. I will. Best number to reach me at is 248-552-5000. I did a bankruptcy for an executive, automotive executive, and he had in his pension account over $500,000. It was IRS protected, but he had no income. He was a high income earner, and all of a sudden he had no job. He lost his house in foreclosure, and he had credit card debt. He was able to file the Chapter 7 and keep his entire pension plan and his 401k, which he needed to get a fresh start.
Okay, in other words, you're out there. You got 5 or 6 credit cards. You're getting these mailings all the time from ABC and XYZ, consolidating your debt and doing this and doing that. You know, we're going to take your $35,000 in credit cards and we're going to consolidate them all into one credit card. So you're paying for it and you're struggling because they got you by the neck. And I mean, they really have you by the neck. So your fixed income, listen, because this is really important for you out there. Your fixed income between your Social Security and your pensions, $3,000 a month. You're paying $1,200 a month for rent. You got to pay for your car insurance. By the time you get done, you got $1,000 a month to live on. But out of that $1,000 a month, you have to pay $400 or $500 a month to your consolidated debt. You might as well file for bankruptcy.
That could be a good financial tool to reorganize. You're not going to have access to those credit cards again afterwards, but you'll relieve from your head the pressure of trying to pay a credit card versus buying food.
Yeah, the idea is you'll get rid of all that debt and you won't struggle.
Correct. And
that's the point. That's the big issue. You won't struggle anymore. And that's the problem because people keep on getting credit cards and they're paying anywhere from 18 to 24% interest on the credit cards. So when you're paying 1.5% a month, it doesn't sound like a lot of money, but that's 18% a year.
Believe it or not, I saw a new car loan for 22%. And this is part of the problem too. I know we live in Detroit and cars are very important. Everybody wants to have a car, but sometimes they'll take advantage. Someone's got poor credit, wants to buy a new car, and they'll sell them a new car at 22% interest. The interest part of the payment is more than the value of the car, and soon you'll find that the car is worth so much less than what you encumbered yourself for. It's a mistake that shouldn't have been made in the beginning, but people are taking advantage of it. And bankruptcy is a possible way of leveling the table and the playing field.
In the grand scheme of things, here's what we have to stop doing. We have to stop worrying and start thinking about what we're doing. If we worry about it and we're looking for Band-Aids, we're going to end up not taking care of the problem. If we think about what we're doing and call people like Ray Saloom who have answers, he doesn't charge for telephone calls. He'll answer your question. He'll tell you whether you're on the right track. What's the average cost of a simple bankruptcy?
Simple bankruptcy is about $1,000.
What's the filing fee for that?
$335.
And that's in addition to the $1,000.
Correct.
And that's not bad if you relieve yourself of $40,000 or $50,000 in debt.
I believe it's a good bargain. But you don't want to jump into bankruptcy unless you have an overall plan so that when you come out of bankruptcy, you don't find yourself in the same position again. So, and I can give some good advice on that, and there are some good videos that actually the government puts out, the Department of Justice. There's 7 5-minute videos about the entire bankruptcy process. And if you give me a call, I'll direct you to that. And it's free to watch and kind of give you an idea how the whole process works from start to finish.
In addition to that, there are courses that are recommended by the bankruptcy court to teach people how to manage their money.
Correct.
And if you learn how to manage your money and you're fiscally sound in managing your money, you can get back on your feet. You're not going to get rich. If you go to the casino, you're not going to get rich. If you play the lottery every day, you're not going to get rich. If you smoke every day, you're not going to get rich, and you're not going to be able to pay your bills. So you're going to have to make some adjustments. This applies to everybody. And I'm finding the biggest adjustment today occurs after retirement. Isn't that when you're seeing more bankruptcies?
Yeah, unbelievable. Even a teacher that I had many years ago. The circumstances are sad. Pensions haven't kept up with the cost of living. Social Security certainly hasn't kept up with the cost of living. And you'll see people that are struggling with part-time jobs and just to pay the basic necessities.
You know, it's not reasonable when a person retires that in order to sustain themselves, in addition to their pension and their Social Security, that they have to have a part-time job, especially if you're 72 years old. And a lot of older folks, you know, I'm not being critical. I'm still working at 75, so I have no right to be critical. I like to work, but I don't know if I could pay all my bills if I didn't work. I'm being honest.
You know, my doctor told me something very interesting. He's got a group of patients that sometimes 2 generations. The parents could be in their 80s and 90s, and their kids could be in their 60s and 70s, and both generations trying to live off of Social Security. It's tough. In some cases, the older generation passed their wealth to the younger generation to get them started in business, and not knowing that they would live as long as they did, and they find themselves running out of money, going back to their son or their daughter who's in their 60s and 70s, and the money's no longer there.
Right. So bankruptcy is very, very important. I have a dear friend who is 78 years old, and every month he's spending about $2,000 a month paying credit cards.
Wow. Yeah.
And he gets $3,500 a month in income.
That's what does he have left to buy food and groceries and insurance?
$600 a month when he gets all done, because he has insurance on his car, he has heat, light, and gas in his house, and he's a decent guy.
He's got his hands tied at that age.
Yeah, and he had a job, and I'm sharing this with all of you because it's important. He had a job. He ran a little business, and now he has cancer, so he can't do that. So his extra little income that he had coming in every month at $600 or $800 a month that made a difference, he doesn't have.
If I were him, I wouldn't worry about the credit cards at that point.
That's my point. So we've got Chapter 7. And eligibility for Chapter 7, make it real simple. Tell our folks what they need to be, what's it take to be eligible.
Government uses a means test to see whether or not you qualify for Chapter 7 or whether you're able to pay back a portion of your debt. Basically, a family of 2, it's $55,000 annual gross income. A family of 4 is $78,000.
What do you mean by means?
If the total family's gross income, for example, a family of 2, exceeds $55,000, you'd have to show special circumstances why you should be allowed to file a Chapter 7, discharge your debts, versus trying to pay back a portion of the debts. And that came about in 2005 when they changed the bankruptcy code.
Good morning.
Hey, how you doing?
How you doing?
Good. You guys still repair television?
Yeah, we're on television.
No, I'm saying you guys repair company.
I'm sorry?
Do we what?
Is this a TV repair service?
No, I haven't done that since I went to law school. Okay, thank you. Yeah, I work for a TV repairman, that's okay. So getting back to what we were talking about this morning.
Sure.
So the means test.
The means test is a manner that the government uses to determine whether you should try to pay back a portion of your debts, which would be a Chapter 13. Chapter 13 plans run from 36 to 60 months. So a high-income earner, for example, who wanted to adjust their debts in bankruptcy would have to file a Chapter 13 and come up with what's called a good faith payment plan. So, for example, someone who was earning, say, $100,000 a year, but had a lot of unsecured debt that they couldn't deal with, for example, say $50,000, $60,000, would be in a Chapter 13 and pay back at the rate of anywhere from $400 to $500 a month for the 60 months. But when you file a Chapter 13, you're restricted, not allowed to incur new debt without court approval. So you can't buy a car or lease a car unless your attorney files a motion and gets court approval to do that in a Chapter 13. A Chapter 7 is done more quickly.
Now here's my big question for you. Chapter 7, Chapter 13. I owe the Internal Revenue money, and I want to file for bankruptcy. Can I list the Internal Revenue as one of my debts?
You have to list them as a debt, but whether or not they're discharged depends on a set of rules. For example, if it's 1040 income taxes, and they're more than 3 years old at the time you file, and you filed your returns on time, you can discharge them. If you were an employer and you didn't pay the employment taxes for the employee, 940, 1120 taxes, those are not discharged because that's considered trust money. That means it was never your money to begin with, and the IRS can chase you after bankruptcy.
So if I owe 1040 and I discharge them, what happens?
The debt is gone. If the tax liability was more than 3 years old at the time you filed the bankruptcy, they're treated like other creditors, and it's discharged. The general discharge of debt would apply to those taxes as well.
And then the IRS can't come after me?
Correct.
They can't call me on the phone or send me a letter, tell me they're going to seize my property?
Correct. They're treated like other creditors.
So let's take this one step further. I'm married, I file jointly, but I get the IRS to take my wife's name off the debt because it's my debt and not hers. Then I could file for bankruptcy and get rid of it, couldn't I?
That would be, again, assuming it's more than 3 years old and it's not a trust tax, yes.
What do you mean by a trust tax?
An employment tax or where you were under the duty to hold it or deduct it for someone else and submit it to the government. But you can get rid of those after there's a 10-year statute of limitations on those taxes.
Okay, here's the big question though. If I don't file my tax return, can I get rid of it?
No. That's the problem. If you were hesitant, you didn't file your tax returns because you were scared, and then you file your tax returns and the liability is assessed, the 3-year statute would start from the time the liability is accrued. So if you wanted to try to get rid of those taxes, you'd have to wait 3 years after you determine the liability.
Okay,
So
so I
it's-
understand.
Yeah.
So for those of you who filed your taxes, haven't paid your taxes, and you say you can't afford to pay your taxes, please, if you're listening, call in if you have questions. You can get rid of that debt. You can get rid of the credit card debt. You can start new. It doesn't matter if you're 65 or 72.
Correct.
You can get that monkey off your back and you can live.
And in some cases, that's all you need is a little relief to get along in life.
Now, there are folks who always call me and say, well, I want to file for bankruptcy, but I don't have the money to pay the filing fee. Can you get the filing fee waived?
You can in very limited circumstances. It's very hard. What the court will do is give you a chance to pay it in installments.
Good morning. Hello?
Yeah, I wanted to know, like, if you owe child support, state child support, tax support, and it's over 20 years old, and you file Chapter 7 bankruptcy.
That's a good,
Okay, who do you owe it to? Do you owe it to the government or do you owe it to the individual?
Is Zacharias will take.
It's money over to the state because somebody was receiving assistance, right?
Yeah.
Okay, we just want to make sure we're clear on that.
yes, that's a good question, but unfortunately, the answer is no. You can't discharge domestic support obligations, including money that was taken from the state.
But you can go to the friend of the court. Now, this is very important for you to understand. You can go to the friend of the court and you can get an adjustment on that if you're not financially capable of paying it. There used to be a time you couldn't do that, but now they use a means test. I was just there with a man who owed $66,000 in back support, and we reduced it down to $22,000, and he's paying it off at the rate of $150 a month. So it can be done. But you can't do it if you don't go to the friend of the court. You can't do it if you don't want to engage an attorney to assist you to do it. You can't do it if you turn your back on it. And I'm telling you that for a reason. Because if you turn your back on it, you don't pay it, and you get picked up for even a driving ticket, you can end up in jail for back support, and it can be treated as a felony. You got it?
Yeah. Yeah. Thank you.
Okay, thanks for calling. So that's the reason why the bankruptcy attorney is really important. Tell people how they can get a hold of you now.
I'm on Woodward and Long Lake and Bloomfield Hills. Best way to get a hold of me is call me, 248-552-5000. Easy number to remember.
Now, what's important for you to understand is that Ray is there to assist you and give you information. If you need to come in and consult with him, he's not going to charge you for a consultation. But he's not going to be able to waive the fees for you because that's not his job. You can go down and file your own bankruptcy petition yourself, but if you foul it up, shame on you. No, I'm serious about that. I had a client who called me. He said, I filed up in Bay City for bankruptcy. I said, okay, so what's your problem? Well, I thought I got rid of all my debts, and I got this bill. It's 5 years old for $13,000 after I went into bankruptcy court. Well, your bankruptcy does not cover debts that are not listed. That's rule number one. Rule number two is you can't go back in after 5 years and open up your bankruptcy, can you?
Under very limited circumstances, but as a general rule, no. The courts are not akin to having them reopen. Certainly not to add debt or creditors.
No, but there's a window of opportunity, isn't there?
Yes,
Okay, so if you
closer in time is better,
Yeah.
always.
a year is a reasonable period of time. We're going to take a break for a minute. We'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
So one of the biggest problems that people are faced with is solicitation for debt consolidation. And there are a lot of attorneys who claim that they can consolidate your debts. And I get a lot of telephone calls from our listeners saying, hey, I've been paying for 5 months and none of my debts are consolidated. Where's the money going? I'm not very nice about it. I say it's going in the attorney's pocket.
Yeah, I don't like most debt consolidation programs or promotions are advertising, and just as you said, it's a way for attorneys to enrich themselves, and even some companies, corporations. Some of them, interestingly, are tied to those payday loans companies, those high interest loans, and a lot of the companies behind that, the hard money behind that, are the companies that own these alleged debt consolidation companies that advertise heavily on radio and TV, where they'll solicit you and they'll have you make payments to them, and they said that they're going to settle with your creditors when they reach a certain amount, usually 50 cents on the dollar, 10 cents on the dollar. But I've seen really only one company that's actually done anything close to it, and the circumstances there, GreenPath is a legitimate company, but the time and effort, you've really got to be diligent, and you're doing most of the work yourself. It's a nonprofit company. They'll give you some guidance, and most people that are that far in trouble don't have the wherewithal to save money on the side and know how to contact each creditor one by one and make a deal with them, settle with them. And at the end of the day, for example, let's say you settle a $10,000 debt for $2,000 with a credit card. At the end of the year, you'll get a 1099-C, forgiveness of debt, and you'll have a tax liability on that $8,000 that you saved will be added to your income, and whatever tax rate you're at, you're going to get another bill on a debt you thought you settled. If you're at that point, I think bankruptcy is, assuming that you qualify for bankruptcy, I think bankruptcy would be a better option.
He just said a whole lot here that needs to be broken down. Now, he said it to me, and I'm trained to understand what he said. But for you folks out there who are not trained to understand what he said, and I'm not insulting you, I'm being serious about it, here's what he said. I go to debt consolidation. I've got a $10,000 credit card. So I settle the bill for $3,000. At the end of the year, I'm going to get a 1099 that says that there's a $7,000 forgiveness of the debt. And it's absolute. It's written right into the rules that you're going to get this, because they have to report it to the government that they forgave the debt, otherwise they can't write it off.
Correct.
The credit card, I don't care if it's American Express or Visa or MasterCard or Macy's credit card, at the end of the year, if they forgive the debt, you're going to make a deal with them, you're stuck. There is a way around that, though, and I'll tell you about that in a minute, but let's just follow this thought through. So am I right so far that you're going to get the statement?
Correct.
Okay, so if you have the forgiveness, what he's saying is, why have the forgiveness? If you go to bankruptcy, you discharge it, and you're not going to get the 1099 and have a tax liability.
Correct. Because
Okay.
the underlying debt has been removed.
Right, because the debt's gone. The lien's gone.
Correct. In that scenario, which is many of the cases where people are able to settle their debt, it's at a significantly higher cost than what they may have thought. And again, now you've already damaged your credit too. With a bankruptcy, in some cases, and probably most cases, when you remove the entire debt, you're in a better financial position, including a better credit score than you were before you filed bankruptcy. And I'll tell you why. You can only file bankruptcy once every 8 years. So assuming that someone under this scenario that we've discussed obtains a Chapter 7 discharge, they're a better bet for creditors to get a new car loan, to even get new credit cards, because the banks know that you can't file again for another 8 years. You're better off than someone who's carrying a lot of significant debt and is teetering on the edge.
Okay, so your credit score is not going to be over 600 when you come out of the bankruptcy, but it's going to start to go up after that.
Correct.
And that's a good sign. Now, the only trick on the credit card, if you want to get rid of the debt, is get them to forgive the interest.
Clever. Okay. Have
Yeah.
you done that?
Yes, I have.
Okay.
If you get them to forgive the interest
Okay.
and you pay the underlying debt, then you don't have to worry about the 1099 because it's discretionary with them to forgive the interest.
I didn't know that.
Well, it's a way around it, but it's not the kind of thing you want to do without getting paid for, because it requires time and effort to talk to people about doing it. Consequently, when you go to one of these debt consolidation services and they're going to pay all your debt, it's not going to get paid. You're going to be further in debt when you get done. Your credit's going to be wrecked, isn't it?
Absolutely. Yeah.
Are you listening? Your credit's going to be wrecked. So if you think that the wonder person's going to come in and they're going to take care of you and you're going to pay them $400 a month and they're going to get rid of your debt, $375 a month is going in their pocket. Is that true?
And the debt is still there.
Not a dollar is going to take care of the debt.
Yeah.
You're better off, like, one of the biggest problems people have is co-pays.
Yeah.
Because they're insurance. You're better off going and making deals on the co-pay than letting the debt ride.
Yeah, absolutely.
Oh, and something really important just came up as a flash in my mind here. I have a debt. I don't pay the debt. And the credit card company writes the debt off. But then they sell the paper to another company. The debt doesn't go away, does it?
No.
But you can settle it at a discount then.
In some cases you get a better discount. The further along the account has aged, the more it's aged, the greater the discount.
Okay, let me give you a classic example of that. Your house is foreclosed on. You've seen it many times, haven't you?
Yes.
And
I know where you're going.
Bank of America writes off the debt. For some reason or another, the house is underwater and you're still in the house. They sell the paper. They sell that loan after they write it off for 20 cents on the dollar. So if you owe $100,000, they'll sell it to Raymond for 20. Raymond comes along and says, you owe me $80,000. In reality, Raymond only paid $20,000 for the debt. So you ought to be able to bargain with Raymond on the debt, shouldn't you?
You should.
Can it be done?
It can be done, but a lot of creditors will take advantage of this situation because they'll sue for the full amount, even though the face amount of the note that they purchased at the discount, that's their profit margin, the difference between the 20 and the 100.
I know, but if you go to court, you can fight over that, can't you?
Oh, yeah, absolutely.
And will the court listen to you?
In most cases, yes.
And why will they listen to you? It's really important, listeners.
A lot of people don't question documents that they receive. And the courts do equity, as you know, and most of the judges that I've had on the civil cases, although I'm sure you have a lot more experience than I do on defending these kinds of cases, is the courts, their judges are elected by us. They understand what people have gone through, and they push settlement. They push compromise. The old Solomon, cut the baby in half. Most judges still do that today, whether right or wrong.
So the idea is if you run into a trap like that, don't avoid it. Instead of worrying about it, think it through and talk to somebody about it and talk to Ray about it. He's available. Once again, tell him how to get a hold of you.
The best way is by the phone, 248-552-5000.
Or I'm going to include you in the challenge. Last week, Carol was on, we talked about probate, and we're going to have a program on November the 17th. Well, Ray's going to be there to talk about bankruptcy. So on November the 17th, which is a Saturday, unless I looked at the calendar wrong, from 12 to 4, Law Power Hour is having a program at the Considine Center on Woodward next to Little Rock Baptist Church. We're not serving lunch, but we'll have treats. We'll have coffee. We'll have Pop. We'll have Ray. We'll have Carol. We have another lawyer who's coming to give general information. And if you listeners want any other areas of the law covered, if you want somebody there on workers' comp, if you want somebody there to teach you how to do your own no-fault case so that you don't have to pay some lawyer to collect the benefits that you're entitled to receive, just call us on the air or at 248-335-9266. That's my office, and tell us what areas of the law you want there. And if there's a reasonable need, we'll have people there to give you free legal information. Now, when Ray comes, he comes armed. He's going to have printed information for you, and he's going to explain it so that you and your families can understand what's going on. When Carol comes on probate, she's going to have printed information for you explaining what your rights are. If you need information on automobile no fault, we'll have people there. If you need information on expungement, we'll have people there. It's just going to be a Law Power Hour afternoon where you can come in and ask your questions and get your answers. On that note, we'll be back in a minute.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
So I decided to go into business because I want to make a little extra money. And I'm going to set up a jewelry business or a clothing business. And I formed an LLC. I told you it's going to be an interesting set of questions for you. And I decided to get a credit card. Because when you set up a new business, the credit card people contact you right away. They want to give you credit.
Mm-hmm.
So I get a credit card. And it's in the name of the LLC. Well, my business goes sour. Can I file bankruptcy for the LLC without affecting me personally?
No.
Tell me why.
The only time you would file a bankruptcy for a corporate entity, LLC or corporation, is when you want to try to keep it running. That's called a Chapter 11, debtor in possession. When you close the company, that's it. All corporate debt closed and died with it. Now, the situation that you have mentioned about the credit card, and I've seen this in some of the personal bankruptcies I've done where people had businesses, side gigs, that went south. In almost every single instance, I would say 99% of the cases, that credit card that you thought was a corporate card has your personal liability attached to it as well. So although the corporation is no longer in existence, the corporation's not liable, you as an individual could still be liable, and but you could, again, could discharge that in a personal Chapter 7. I get calls all the time for people that want to, or that mistakenly believe that they have to file a corporation for their business that's no longer in existence. With a few very unique set of circumstances, there's no reason to file a bankruptcy. You can do a Chapter 7 for businesses and for some tax debt and for some other reasons you may want to file, because a corporation or a business that files Chapter 7 has no exemptions. That means everything is sold, liquidated for the benefit of creditors. In some case, I did have an automotive supplier, a small company, had a lot of debt, mostly corporate debt, not individual debt. And the value of the machinery we thought would be worth better to have a trustee sell it in bankruptcy rather than to let the secured creditor come in and sell it. And it worked out pretty good. He had $9 million in debt. He supplied bumpers to BMW back in 2008 when the economy went south. So we filed a Chapter 7 for the corporation. The trustee was able to auction his equipment. Coopers and Chrysler bought some of the equipment at a much better price than he could have sold it on his own. And it addressed a good portion of his debt, not all of it, the corporate debt. He still had personal liability for some of the accounts. And we ended up filing a personal bankruptcy after the business bankruptcy.
Okay, so that was a Chapter 7 for the corporation?
Chapter 7 for the corporation, and then a Chapter 7 for the individual, following the corporation.
So could I use a Chapter 7 for an LLC?
Yes, you could. But if it doesn't own any assets or anything, then there's no reason to file, just close the company. But if there's assets and you don't want to, if you don't want to face a bunch of lawsuits, another way to get rid of everything is just throw it all in bankruptcy and let the bankruptcy court deal with, and that way, bankruptcy court is under federal law, so all state court complaints go away. We talked in the beginning about a bankruptcy stay. The day that you file bankruptcy, whether an individual or a corporation, all court action, everything stays. That means it stops by court order. Then the bankruptcy court will address the disposition of the assets and how the case goes forward.
Right, but you can also end up litigating cases in the bankruptcy court.
Yes,
So on a technical basis, I could file for bankruptcy and I could sue you in the bankruptcy court and litigate the case in the bankruptcy court, couldn't I?
correct. Yep. It would move much quicker in the bankruptcy court than it would in state court.
There's a few little things I forgot to mention to you folks out here. If you get a settlement from a personal injury case and you have money in the bank, it's not exempt, is it?
No, you can exempt a small portion, but in most injury settlements, if you file bankruptcy, the trustee would take it to pay your debts.
Same with workers' comp.
Correct.
If you have a workers' compensation settlement, a lump sum of money, and it's in the bank, you've converted it from the workers' compensation benefit to a lump sum of money, and that is subject to an execution, a lien, attachment, whatever term you want to use.
Yep.
And eventually, the bankruptcy court can get it.
Correct. In fact, lots of times people do things that harm them when they file bankruptcy. They think they're protecting assets. For example, by transferring assets and then going to the bankruptcy lawyer and trying to file bankruptcy. In most cases, they've made it almost impossible to file bankruptcy without dragging these people you've transferred assets to into the bankruptcy court.
Give us an example of that. It's important to understand.
Okay. For example, transferring a deed to a house to a son or daughter and then thinking you can file bankruptcy, the trustee could set aside that transfer, take the house, which may have been exempt, which is no longer exempt because of the transfer you did, and the trustee has what's called clawback powers. They can undo transfers of property to more equitably divide the property over the debtor's creditors.
How far back can you go in your clawback?
For different events, transfer of property can go back 5 years.
So you could have a 5-year back rule on the transfer.
Trusts, 10 years in 1 day.
Okay, so you could have a situation where you transfer the property and you file bankruptcy and then you die. And then they could forget about your estate, they could still go back if you file bankruptcy first and get the property, couldn't they?
Correct. The people you transferred would find themselves in litigation with the bankruptcy court.
So the idea is if you have any financial issues and you want to find out the best way of handling them, is to call an expert in the field of creditors' rights. And that's what it's all about, isn't it?
Should always seek advice first before acting.
Just so our listeners understand, can they come in for a consult on a creditor's rights problem and get an answer from you?
Yes, I give free consultations, either over the phone or in my office.
But you got to give them the full picture of what's going on. I know we didn't have many calls today, so I expect to see you on November the 17th, on a Saturday from 12 to 4. I want you there. I want to meet you. I want to talk with you. I want you to meet Ray. I want you to meet Carol and all the other people that are coming down there to give their time to give you free legal information on areas that are important to you. Ray, what would you tell our listeners they should do if they have financial problems?
Pull together your documents, last 2 years of tax returns, all your bills, and give me a call.
And what kind of formula do you use in determining whether somebody should file for bankruptcy? Because there must be a formula.
What I put myself in the same position. You know, if this were me, what are my options? You know, and in some cases, bankruptcy is not necessary. For example, someone whose sole income may be Social Security, unless if they want to stop the phone calls from coming in. They're basically bulletproof because judgment creditors can't attach Social Security benefits. So if someone has minimal debt, $10,000, and they're on Social Security and that's their only source of income, it may end up costing, for $10,000, you're going to spend $1,300 to file bankruptcy. And you know, if bankruptcy is not going to put you in a better position, I'll tell you not to do it. If bankruptcy is going to make, you know, for a younger person who's going to need future credit and need to reorganize for kids in school or whatever, bankruptcy may be the quickest and simplest way out of your past debt. But you've got to change your lifestyle. And the people that come out of bankruptcy the best are the ones that learn from the past, the mistakes that put you there, and are able to budget. You know, it's very hard. I know for myself, with kids in college, money goes quickly. And it's hard to make choices.
Well, that's what it's all about. It's making choices. It's making the right choices, because all of us who have children have responsibilities when it comes to our children. And we all want to accept and handle those responsibilities and not worry about them, so we have to learn to budget. However, I ask you a question. What's a rule of thumb? If your debts are 50% of your income, should you look at filing bankruptcy?
I think that's a good rule of thumb, 50% or more, because how are you going to address that with your current living circumstances going forward? And if you get that debt relief, that may be just what you need to concentrate and focus on the future.
Now, listen to me very carefully. If your debts, not your expenses, are 50% of your income, that's a good way of looking at it. If you take your debts and your expenses and they're more than 80% or up to 80%, then you better get help today. Because you can't pay your bills, you can't live, and you're underwater. I don't care what you say, you're underwater. So now I've given you two simple rules here. Add up your income and add up your debts. It's 50%. You better talk to Ray. Give him your number before we go off the air.
Again, 248-552-5000.
And this applies to anybody, rich or poor. If you have these questions, you can call Ray and ask him. And I use rich or poor. You're not poor in terms of living. You may be poor in terms of your ability to pay your bills and live. Have a great week. We'll see you next week. Thanks for listening.